Good afternoon, everyone. I will talk about a couple of cases that we came across during our sanctions practice. The first one is the most straightforward and the easiest one. You are a Russian national living in Russia, or let's say in Dubai. You're not subject to any sanctions. However, your Swiss or EU bank has frozen assets on your bank account. What are limitations on bank accounts for Russian nationals? Swiss and EU banks are prohibited to accept new deposits from Russian nationals if the value of the account exceeds 100,000 euros or Swiss francs. This rule does not apply to those Russian nationals who also have Swiss or EU passport or the passport of EEA, or if they have a temporary permanent residence of these countries. There's also no restrictions for outgoing payments. And actually, European Council has stated in its FAQ so that if a person, the Russian national, is not sanctioned, there is no legal reason to block his or her bank account just based on the fact that he or she is a Russian national or because of recent geopolitical situation. Also, if you have prior to February 2022 a bank account with more than 100,000 on your bank account, let's say a couple of million, you can keep this money. It's not be taken away from you. You can do what you want. You can spend it or transfer it to another bank account. What do you do if your bank does not agree with you? You can get a legal opinion addressed to bank stating the rules. If this doesn't work, you can submit an application to SECO or EU authorities. Talking about SECO, it will take most likely very long for it to consider application because there's no national interest, and also in this type of cases, most likely SECO will not issue anything in writing, but may talk to banks directly. And step number 3 is to go to court. So speaking about sanctions, it's important to mention that Swiss and EU banks have to comply not only with Swiss and EU sanctions, but also with sanctions of other countries such as US and the UK. And here it's important to distinguish which, for example, if we talk about US, which US sanctions apply to European and Swiss banks and in which cases. Here is case number 2. You are a Russian national, you are not subject to any sanctions, but your relative, let's say a parent, spouse, or child, is designated in the US, and a Swiss or European bank has frozen your bank account. Does a designation of your relative apply to you? The answer is no. By operation of law, the sanctions that censor designations of a person does not transmit to his or her parent or spouse or child. There is one exception if it is shown that if it is determined that you are acting for and on behalf of your designated relative, that there is a sanctions risk. How do you know? How can you know if you're acting on behalf of a designated person or not? Then we need to look at the facts and analyze them. A typical example of when you are not acting on behalf of your sanctioned relative is when an account was initially set up for your benefit through a trust structure or foundation structure in which you are a beneficiary, or maybe your common kids are also beneficiaries. So this type of bank account should not be blocked because historically it shows that it was for your benefit and not for the benefit of your designated, let's say, spouse. Sometimes banks can ask such client to go to OFAC and get a confirmation from them, but actually, in this case, OFAC would not have any jurisdiction over this transaction, over this case, and would not issue any licensing authorizing transactions. Another question that we also experienced in our practice, as with all European banks, can they prohibit transactions on this bank account based on secondary sanctions, saying that no transactions can be processed on behalf of a spouse or child of a sanctioned person? And actually here the answer is you have to look at the specific sanctions program. Under current sanctions program of the US that was implemented by Executive Order 14024, this is not this is not prescribed by the secondary sanctions. In other earlier sanctions program, there is something like this, but not in the current one. So what do you, okay, so here is the most difficult case number 3. You are a Russian national, not subject to any Swiss or EU sanctions, but you are designated in the US. And Swiss bank or EU bank account was frozen by your bank. Here we come to the question whether US sanctions apply to Swiss European banks. It is important to distinguish between primary sanctions and secondary sanctions. Primary sanctions require US nexus. They state that all property in the US or in the possession of a US person has to be blocked. Also, primary sanctions may apply to non-US persons such as Swiss or EU banks when they transact with a sanctioned person. When a transaction occurs through a US person or in the territory, in the US territory, let's say if FFI, foreign financial institution, processes a transaction with a sanctioned person through a US bank, let's say it's a US dollar transaction, and primary sanctions give rise to civil and criminal penalties that are maybe like very high penalties. So how do I know if how does the such sanctioned person, or how does the bank know whether US persons or US territory are involved? So we have to look at the assets. For example, there are US dollars and US securities on one spectrum. On the other spectrum, there are precious metal accounts. So if you do a transaction with US dollars or US securities, most likely there will be US nexus. If such sanctioned person has a precious metal account, then it is unlikely that any US person or US territory will be involved. Also, the same applies to any licenses issued by OFAC. OFAC, if it doesn't have any jurisdiction, it will not issue any confirmations or licenses. Talking about secondary sanctions, they are very different from primary sanctions. So when you hear about risk for banks to be cut off from US financial system, these are secondary sanctions, and they do not require any US nexus, and they apply directly to non-US financial institutions, and the secondary sanctions prescribe non-US financial institutions not to engage in certain transactions. And how do banks know whether secondary sanctions apply to them? They need to look at the relevant sanctions program. Currently, Executive Order 140/2024, this is the current, most recent sanctions program, prohibits only certain transactions with certain SDNs, which are involved in Russia's military industrial base. So, for example, if you are a business person who has nothing to do with military industrial base, these secondary sanctions would not apply to transactions with you. So what do you do? you get legal opinion addressed to banks, which are related to EU and Swiss regulations, and also it is important to get an opinion from a US lawyer. In terms of OFAC, I already said that OFAC, if there's no jurisdiction, OFAC will not issue any licenses. And finally, if nothing works, then you can go to court, which will apply US law.